Welcome to You Can't Say That in Court, a podcast by Rise Women's Legal Center. I'm Vicky Law.
And I'm Stephanie Melnick. We are your hosts in this conversation about survivors of violence navigating the BC family law system. We recognize that this system is colonial and causes harm to families, and that disproportionately impacts Indigenous people.
By speaking more widely about these harms, we hope to raise awareness about the challenges that survivors face as they navigate the colonial family law system. This podcast is our attempt to collectively identify the barriers and ask for positive changes to be made. Thank you for joining us. Our podcast series will discuss difficult topics such as gender-based violence and intimate partner violence, including physical, sexual, emotional, psychological, and financial abuse. Please be aware that this is a thread that is woven throughout all the episodes, and we hope that you will take care of yourselves however you need.
Hi, everyone. This is Stephanie Melnick. I'm so glad you've joined us again for You Can't Say That in Court. This is part 3 of 5 of a lawyer panel about how different areas of law can intersect with family law. And just to note, in this episode, Steph H refers to the director, and by this she means the role at MCFD designated to bring their concerns to court, just so you understand that reference. Today, we're getting into the additional problems that come up for survivors when they're being investigated. There are a lot of messy pieces. So here we go.
So we've talked a little bit about, very interestingly, the restriction on or the constraint on finances that lots of clients and survivors have. But then also, Melissa and Stephanie, you started to touch on a little bit about investigations that might be ongoing, whether or not the allegations were well-founded or not. Just making a complaint or a report to a number of different agencies that have an investigative body can end up causing a lot of harm to a survivor, not only in tapping out their financial resources or taking up a lot of their legal aid hours, but then also how to prioritize the different proceedings or processes that are going on. If we can talk a little bit more about that specifically, I'm thinking in the criminal realm, it's reports to RCMP, in child protection, it's reports to MCFD, and in immigration, also IRCC has an investigative piece to it. And that can really complicate not only family law matters, but just the whole process that a client is trying to go through. Stephanie, can I pass it to you first?
Yeah, thank you, Stephanie. It's these intersections are complicated, and it's one of those situations where folks don't realize what they're dealing with. Oftentimes, even when they're in it, they don't realize exactly what they're dealing with until it gets to the point where they are dealing with a number of different lawyers. Perhaps their children are removed, or there's been a threat of removal, and all the situation comes essentially avalanching down upon them, and they're dealing with all these different areas of law at the same time. As parents counsel in family policing matters, I often have to explain to my clients, I give them like a mini lecture on the burden of proof, standard of proof that is dealt with, because a lot of folks are aware of beyond a reasonable doubt, which, the criminal standard, and just breaking it down to basics, I explain that to folks as, listen, if this goes before a judge in the criminal context, the standard of proof is beyond a reasonable doubt. The judge is going to go, okay, am I 99% sure or greater that the accused did the thing they're being accused of? And that's where convictions come from. That's the way the system's supposed to work. We know that's not always the case. In family policing, in family law, so under the Family Law Act, it's generally the civil standard is used. So balance of probabilities, I break that down for folks by saying, so the difference there is that instead of it being 99% sure, the judge goes on balance. So like, is it more than 50% likely that a thing is either in the best interest of the child or an order should be in place? The exception to that in family law is for child support, where there are guidelines and tables used. So a lot of folks will go, well, why won't there be more child support ordered? And the answer is because this is how we do it. A lot of the time is bureaucracy and numbers. In family policing, the standard at the beginning of the process, the standard is likelihood. So social worker goes, it's likely that this thing happened. And oftentimes they'll go, well, if there's an RCMP investigation going on, then we're going to go, okay, we'll side with that. We'll go, well, if the RCMP are going to investigate, then we figure it's likely that something's up. And that's where that safety planning piece comes from. That's where that threat of removal comes from. And that's where we see my clients come to me and they go, I feel like I'm being punished. I feel like I'm being punished by the social worker because I entered into a relationship. Like, we'll use the same example as before. I entered into a relationship with somebody who I think is a really great person. They've acted as step parent to my children. I think they're spectacular. And now there's this RCMP investigation, and I don't know. Mom doesn't know. She doesn't know if it's founded or not. She doesn't know if supporting her current partner is going to put her at risk, going to make the social worker go, well, you supported them, so you're not a protective parent. So your spouse should have majority parenting time. And although that's technically an FLA decision, it gets made by social workers all the time and not based on balance of probability, based on likelihood. So it's a situation where even though, and situations where criminal charges are never laid, I certainly get folks going, well, the charge was never laid. It was never laid. So there shouldn't be a problem, right? And then I go, well, on the criminal defense side, talk to your criminal defense lawyer, of course. Or I've spoken to them and they've confirmed no charges laid, no conditions in place. On the criminal law side, the RCMP side, law enforcement, you're good to go. Step parent's great to move back into the home according to the police. However, the social worker now has said, well, MCFD is going to investigate, so the safety plan is going to stay in place. And so it's that piece of confusion where parents are going, but the cops said it was fine. The cops said it was fine. And I have to explain the different layers, right? The different pieces. And all of this interplays with the fact that generally, if the parents are separated, there's an order and agreement in place. We've got abusive parent off to the side going, well, the RCMP investigation's over. However, MCFD is still investigating. So my position is that I should have more time with the kids. My position is that you're not a very good parent. I'm going to remind the children that your step parent's not in the home, right? That piece. So that's often where I find myself. It's a bit of a blender of those bits and pieces. And then, as we said, as we talked about earlier, right? Not being able to assume literacy levels, learning disabilities, comprehension abilities. I know that oftentimes when I go, okay, let's talk about beyond a reasonable doubt for balance of probabilities. My clients, the shades go down because in a world where you're worried about housing, medical needs, education, childcare, food security, et cetera, ministries involved, police are involved. Who wants to listen to old Steph giving a mini lecture on standards of proof and evidence? Like, nobody. I know that. I don't even want to. But right, like it's that piece of like, oh, now my lawyer's going to talk at me. But I'm going, in order to do my job, I have to take my time out of my day, out of the work that we do together, and out of my legal aid contract hours to explain this piece to you, because you have a very valid question. And that question is, why is it that an investigation happened and the RCMP didn't lay charges, Crown didn't lay charges, right? No charges. But still I'm dealing with the ministry. Why hasn't the ministry just gone away? And that's part of the move towards that language, that family policing language of parents going, why is it that the actual police aren't involved anymore, but I'm still essentially under surveillance?
What we see here a lot too is there's an allegation made and the police attend, and in British Columbia, it's up to the police to lay the charge or not. And let's say they don't lay the charge. Well, sometimes that emboldens the abuser to now they've gotten off, they're free to continue whatever it is that's going on. And the complainant sometimes loses faith in the system to protect them, and they'll come to me and I can tell they're not trusting in protective services. They're not trusting in the court process. And it's hard for me to convince them to rally in FLA proceedings when that's been their experience. Or her abuser is charged, and I do criminal law, so I've read statements. It'll be a 4-page statement from the complainant where the right questions, in my mind, were not asked. The probative value of the statement is pretty low. And then, I mean, in Revelstoke, it can take 6 months to a year to get to trial. Well, complainant might be beaten down by the time we get close to trial in terms of, I don't remember what happened. Like, they don't remember what happens often because it's very traumatizing to experience that. So now they're feeling deflated. Crown is busy. Crown calls them to do an interview before the trial and Crown can only proceed if there's a substantial likelihood of conviction. And the other important bit is Crown is not lawyer for the complainant, nor are they lawyer for the accused. They are there to administer justice. So complainants get this false sense of Crown is my lawyer. Crown is not your lawyer. They're wonderful people. They're doing hard work, but they aren't your lawyer. So the complainant won't understand the process, won't understand that they should have offered more information to the police, or the police should have asked different questions, or that sort of thing. So sometimes the negative experience with the criminal law interaction can color a person's view of the courts in general, or their ability to advocate or convince people of what's gone on can be eroded. So I've seen that bit quite a bit.
Yeah, I see a lot of folks, Melissa, on that note. A lot of my clients will be the person calling law enforcement, and then they end up being the person charged with things, right?
Yes.
Or there's a dual charge where and literally the classic, it's the classic he said, she said, that police are called, they show up, and she goes, X happened, he did this to me, and then he goes, well, she did this to me, and the cops charge both of them, and they're both on condition. And dealing with that, there's also the traumatized people who are victims and survivors of abuse, of family violence, often dealing with things like PTSD, CPTSD, ingrained trauma, multi-generational trauma, intergenerational. And I certainly have a number of clients who, when they see law enforcement, they very much do fight or flight. So they'll either take off or they are ready to fight the cops, even though their rational minds 100% know this is not helping anything. It's as survivors survive, right? Their brains go into full survival mode, and then they end up folks charged with assault PO, folks charged with resisting arrest, those pieces, where all of a sudden in the number of charges where the historic abusive partner is charged with one thing, and the person who called in to make the complaint to police is charged with 3 or 4, and having to deal with all those criminal charges. And as child protection, family policing, parents counsel, oftentimes, because I don't have time and trying to connect with busy criminal defense counsel on Vancouver Island can be really, really, really tough. Trying to find which Crown to talk to can be incredibly difficult. Rate all of those pieces. So I end up going, hey, what's going on with your charges? And it turns out that their trial for the charges, as you mentioned, is 8 months, a year down the road. But we've got child protection proceedings in court next month. And we've got social workers going, well, if the Crown approved the charges, so there's a likelihood that they did it. The likelihood that we figure they're going to be convicted. And even if they're not convicted, we figure they did it anyway. So let's put that into and we see it in the child protection court documents, the report to court, the protection forums all the time, where it's parent was charged with X, and the implication, the inference very much is charge equals they did it. Yeah. And that's where likelihood comes in. Yeah.
The other multi-agency thing we see quite a bit is abusers charged, and then the next day they might decide, well, mom has some substance use problems and mom has mental health problems, and I'm going to call MCFD about that camping trip last summer, or I'm going to call MCFD because you yelled at me in front of the kids and blah blah blah. So they'll use that as a way to penalize mom, because then of course there's some investigation that should occur. Also, it seems like a small detail, but it's so prevalent, is abuser will call CRA and say, well, I've had the kids most of the time, so she shouldn't be getting the child tax benefit. And that's a substantial income source for many single mothers. And now CRA will just freeze it, do their own strange investigation based on their own information and make a determination. But that could take months and months and months. And interestingly, CRA doesn't care a lot of times what agreements and so forth might say. They make their own determination. And so that can be another logistical financial burden to the complainant that is a real problem.
Certainly. I've had a number of clients where they have, the order in place is that mom has majority parenting time. Mom's been receiving the full child tax, the CCB, over time. And then somewhere along the line, it goes to where each parent has more than 40% of the time. So they should technically be splitting the CCB. And CRA is never made aware of it. Mom doesn't even know it's a thing she should be self-reporting to the CRA. And that's the threat that hangs over. It's like, well, either play nice from the abusive parent, do what I say, or I'm calling CRA, and they have grounds. They have grounds to make you owe this money back. And for somebody who's been receiving hundreds of dollars a month, technically more than maybe they should have been, but that's been allowing them to survive and care for their children over time, because housing costs don't go down, right? We all know this. Mom's housing costs don't go down just because the kids are only with her 45% of the time instead of 65% of the time. It's the exact same cost for housing, which is exorbitant across this province now. So I have a lot of folks. That's another collateral thing that I do with people is helping them deal with the debt, helping them deal with the fact that the CRA has said, you now owe us back half the child tax for 3 years. And that's tens of thousands of dollars for someone on limited or no income who has been relying on child tax and whatever other small benefits they've been receiving. So it's another one of those situations where technically, legally, it's technically not incorrect. However, it's also a huge tool for abuse.
And in all these investigative bodies, it's another barrier for moms or like our clients, right? Because they are the ones with the responsibility to prove that these are false allegations. In the CRA situation, it doesn't take much to call them and been like, hey, you've been overpaying this person. And now we've also have clients at Rise where they're like, not technically a family law issue, but mom needs to show evidence now of that she has care of the children the majority of the time, going to doctors and schools, getting letters and like proof of these things. And it's the same for immigration. I'm just like thinking of times where the abusers have called immigration and say, this was not a genuine marriage, I was taken advantage of. Immigration they don't have a mandate to investigate. So sometimes I can't tell clients that they are going to investigate. But it's up to them to decide, which is, again, the unknown is scary. And again, it's on the survivor to prove the genuineness of the relationship and remembering the history of the relationship, getting text messages, pictures, and gathering all that evidence to show and demonstrate that she didn't take advantage of the person. And it's interesting when we talk about the overlap between criminal and CFCSA, because I'm thinking of the overlap with immigration as well. If our clients, the mom is charged with, if criminally charged, as the immigration lawyer, I can't do anything until that's resolved. And so because immigration, there's criminal inadmissibility if someone is proven guilty or there are restrictions on their applications to stay in Canada. And so I've actually had a client who had the CFCSA issue, criminal issue, immigration issue, and a family law issue. And all of these lawyers had to coordinate with each other and say, okay, we have to deal with criminal first and then family, or criminal first and then child protection and then family and then immigration, because all these layers intertwine and talk to each other. And it's really important, I think, for us to talk to other professionals who are helping the mutual client to figure out what the strategy is. And then there's like I've also want to share an example where that my client had they call it a removal order also in immigration, which is confusing because I'll just call it a deportation order here. they were being deported, and she had ongoing family law issues happening, and she had to go to court and say, I'm being removed from Canada, and I want to take the children with me. And the family court was like, no, it's in the best interest of the children to stay here. And so it was in a jurisdiction where custody and access are still used. And so the court transferred custody over to dad, even though there were allegations of violence. And so mom's now lost custody, needing to be deported from Canada, and went back to immigration and was like, I just got my family law situation changed. I can't take my children with me. I need to stay here. So there's all these layers that I think when we're only practicing in one area of law, it's hard to see what other intersections there are and the priorities that need to be taken into account, and the necessity to talk to these other lawyers who may be involved in our clients' files.
Also for criminal and family, because there'll often be two orders. There will be an undertaking and a family law order that are restricting the abuser. But what happens is they don't mesh. Like one will say no go, no contact, blah, blah, blah. And another one might say something different. And what happens is we might all understand how that works, but the complainant and the abuser who have to keep living there'll be confusion about it, and confusion breeds all sorts of other negative things. And so I've had to really spend more time on thoughtful, and it's hard in a legal aid practice, but thoughtful family law orders and understanding the criminal obligations of the abuser. And so that the two work together, and so that it's clear for my client what her rights are and what her boundaries can be and what legally is protecting her and what's not. Then there's this difficulty always of the school, which happens where maybe the family law order says both parents can attend school functions or something like that. Well, abuser might go to that school function and make it clearly uncomfortable, maybe for the kids, or also particularly for mom. And the schools are in really difficult positions in trying to navigate those things. And I know here our school will only respond to court orders, which is a fair position for a school to take, given their priorities. But so it goes back to me having to spend more time than I used to in understanding the context of the family and how it operates and what the needs are and just where the possible interactions are going to be. And then also understanding the what obligations apply to the abuser so that I can consider those in the family law context, because criminal law orders will trump. Like most family law judges want to know in family court, they just seem to think, oh, there's criminal proceedings and that's a priority in terms of what they're looking at. Or they'll often say to me, well, there's criminal proceedings, we'll wait till those are done. And I think, well, that's a year away. And so yeah, there's a bit of a mystique between the two processes in court, which is difficult.
There certainly is, Melissa. In situations where either the director takes an order or there's safety planning in place, I've certainly had situations where abusive parents will apply under the Family Law Act to enforce a previous family law order that does not take into account the nuances of the current family situation. And it does, the judge's hands are tied, because it does generally, the pyramid goes, the criminal conditions are up at the top, any director's order or safety planning comes next, FLA comes after that, and then as Vicky said, right, the immigration falls oftentimes after the FLA piece. But it still clogs up the works. It still means an additional level of stress for my client who goes, I've been served again. I've been served, and I have to go back to court. Here's the court date. I've been served again. Here's this additional level of stress and oftentimes exhaustion, because litigation abuse is real, and oftentimes it's that exhaustion piece where that's what makes folks cave. That's what makes the non-abusive parent go, I know that I have a case, right? As counsel, I go, you've got a case. Let's make this case. Let's do this. Let's pound it out. I need this much of your energy. I need this much of your attention and your time and your resources. And they go, I can't do it. I can't do it. I gotta be present for my kids. I'm the one doing all the school run, especially when there are conditions in place where the abusive parent is not involved in the day-to-day parenting. I got to do all these pieces for my kids. And so it's the client going, I know it's in the best interest of my child for me to cave in some way, legally speaking. And that, again, it's such a tough spot to be in as a lawyer, because of course we follow our client's instructions. And in those cases, often it's the client going, they explain back to me, and I know in my mind, I'm going, you clearly know what the effect of you doing this is. Like, I'm not able to say, let's just work with, let's go through it again. Let me ask you some more probing, like, sensitive questions. Let me see if there's, there might be a piece you don't understand that's going to make you change your mind and go, let's go back to court. But in a lot of cases, it's a very sensitive parent going, I know what the other parent is capable of, and I know that if I keep fighting on this, it's going to be another year plus everything else I have to deal with in my life. So
I find too in our rural courts, so there's obviously pros and cons, but we get the same judge most of the time. And that's a real pro compared to when I was in a bigger center, because he's often, it's a he that we normally get, but he's often very aware of the previous applications. He's got a good memory that way, and aware of the family. And maybe he's the same judge who that morning heard the accused in criminal court, because we have a remand list that starts with criminal matters and then moves to family matters. And I see that as a benefit sometimes, that the judge is seeing the frequency of applications from certain parties and knowing the context. The flip side the downside in a small town often is we have our criminal matters and our family matters. Well, it's open court. So my poor client mom is standing in front of a room where she knows this is a small town, half the people behind you. And now you're standing up there going on and on about your finances, your spouse, and maybe people in the room are people that provide childcare to your kids or such whatever. But there's it's a deterrent, and it can be used against her later when maybe his friends are in the room or his coworkers or whatever. And obviously we can't ask to exclude the public. That's not how our courts work, but for most circumstances anyway. But that in a small town can be really difficult.
Well, and we should recognize we've got a judge shortage in provincial court and BC Supreme Court in this province. And we've been told that more will be appointed, and hopefully very quickly. It's not happening very quickly. But yeah, on the one side, there are judges who are very, very familiar and have been dealing with the same folks in criminal and family and child protection court for years and years and years. But maybe they're not up on the recent education. Maybe they aren't super trauma informed, right? Many of them are, which is spectacular, don't get me wrong. However, there is that, right, the two sides of the coin. On the one hand, we're going to get a whole bunch of new folks coming in. But on the other hand, there's that hope, right? Without knowing, there's that hope that they're going to be very educated, that they will be trauma informed, that they'll be aware of the effects of family violence on for a long term, that maybe mom will make a decision that in future gets used against her. And maybe a judge will go, you know what? I know, maybe in their own practice or as a judge, they're going, I know that it's not uncommon for a parent to make a decision in family law, like an FLA court, that's maybe against their parenting interests. However, they're balancing it with the bigger picture. So I'm very hopeful that over time, the bigger picture judges will become the vast majority of who we're dealing with.
So that was Steph H, ending the segment with a hopeful note that one day we might have effective coordination between the different areas of law. Thanks for listening to this ongoing discussion about some of the problems that come up when different areas of law are involved all at the same time. We're about halfway through, and next time we'll continue the discussion to focus on how lawyers can collaborate with each other. Thanks for joining us, and we'll see you all again in 2 weeks. Everything that we have said today is not legal advice. If you or someone you know needs legal advice, please consult with a lawyer. We want to acknowledge that this podcast would not be possible without the generous contribution by Women and Gender Equality Canada, Femmes et Égalité des Genres Canada.